Welcome to the Bar Exam Toolbox podcast. Today we're talking about corporations, also part of the broader topic of business associations, as part of our Listen and Learn series. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. In this podcast, we're going to discuss corporations. Even more specifically, we're going to discuss how corporations are formed, what happens when formation isn't completed, and pre-formation contract liability. Although some of the terms and concepts might be unfamiliar, don't worry, we'll explain all of the terminology and concepts that you need to know. To review these rules and illustrate these concepts, we'll go over two hypotheticals adopted from the California Bar Exam. So let's dive into our first hypothetical adopted from the February 2013 California Bar. To view the full hypothetical in question, you can check out the link in the resources page at the end of this transcript or in the show notes. Also, feel free to take notes as we dive in. Okay, on to the question. In 2011, Lenny started a computer software business. During the first year, Lenny sold several copies of certain software programs, and the business made a profit. In January 2012, Lenny hired an attorney to incorporate their business under the name Software Inc. The attorney properly prepared all necessary documents to incorporate the business, but carelessly failed to file them with the Secretary of State. Lenny continued to make sales calls to sell the software. Due to brisk sales, Software Inc. projected income of about $300,000 per year for the next 5 years from the service contracts alone. Software Inc. obtained a $100,000 business loan from National Bank secured by the accounts receivable for the service contracts. Unfortunately, sales later collapsed. In July 2012, Software Inc. went out of business, leaving negligible assets and the unpaid loan to National Bank. Now, with this hypo, we have a couple of core issues to address regarding liability. First, is Lenny liable to National Bank on the unpaid loan? Second, is Lenny's company, Software Inc., liable for the unpaid loan from National Bank? To answer this question, we have to understand a few concepts. In particular, how is a corporation properly formed? What does it mean for liability when it is? And what does it mean for personal or corporate liability when it isn't? Under the Revised Model Business Corporation Act, or the RMBCA for short, a corporation is not formed until the date that the Articles of Incorporation are properly filed with the Secretary of State. All the proper formalities must be followed, and our Articles of Incorporation must contain 4 specific things. First, the corporate name. Second, the number of shares the corporation is authorized to issue. Third, the address of the corporation's initial registered office, and the name of its initial registered agent at that office. And fourth, the name and address of each incorporator. Now, let's add a specific legal term here that you'll likely come across. When our corporation is properly formed, we call it a de jure corporation. Having a properly formed corporation matters because when we have a fully formed corporation, those running the corporation, like Lenny in our example, get the benefit of limited liability. But what happens when we have an almost formed corporation? Well, we have a doctrine for that. It's called the de facto corporation doctrine. Under the de facto corporation doctrine, a defective corporation, one that wasn't properly formed, still enjoys the same benefits and powers of a properly formed corporation, and so our owner-promoter will also get the benefit of limited liability. But note that a promoter is someone who is acting on behalf of the corporation before it's actually formed. Now, when do we have a de facto corporation so that we can exercise this doctrine? We have it when the following elements are met. First, there was a good faith attempt to incorporate. Second, the corporation was otherwise eligible to incorporate. Third, some action was taken indicating that the entity considered itself a corporation. And fourth, the promoter was unaware that the corporation was not properly formed. Next, we have one more doctrine that can apply to allow for limited liability when we have our almost formed corporation: the incorporation by estoppel doctrine. Under this doctrine, any person or entity that treated a business as a corporation can be estopped from denying that the business was a corporation, regardless of whether the business was properly formed. The doctrine applies to both third parties that treat the business as a corporation, as well as to the entity that held itself out as a corporation. So now that we've reviewed when we have a de jure corporation, when we have a de facto corporation, and how to utilize the doctrine of incorporation by estoppel, let's take a look at what happens when we have none of these things. In other words, we have a fully failed attempt at incorporating the company, and the de facto corporation doctrine and the doctrine of incorporation by estoppel can't help the promoter. When we only have one owner, as here with Lenny, similar personal liability rules come into play as those under sole proprietorship principles. In a sole proprietorship, the owner is personally liable for the debts and obligations of the business. Okay, with all of that, we're ready to answer our hypo. So the first step at answering our liability question, both for Lenny and for Software Inc., is to determine whether we had a properly formed corporation in the first place. In other words, was there a de jure corporation? Well, here, Software Inc. was not a properly formed corporation, even though Lenny hired the attorney to file the Articles of Incorporation with the Secretary of State. The attorney failed to properly file them. As a result, a de jure corporation was never formed. Because we don't have a de jure corporation, let's see if any other doctrines may apply. Lenny, to avoid personal liability, will argue that we have a de facto corporation. Here, Lenny did take good faith steps to incorporate the company. He hired an attorney who drafted the Articles of Incorporation, and the attorney simply failed to file. There are no facts indicating that Software Inc. was for some reason ineligible to incorporate. In addition, Lenny considered Software Inc. to be a corporation. He made sales on its behalf and believed he was securing the loan from National Bank for the company. Finally, Lenny was not aware that the corporation had not been properly formed. As a result, Lenny can likely successfully contend that Software Inc. is a de facto corporation, thereby shielding him from personal liability on the bank loan. In addition, Lenny could make an argument that he is not liable under the doctrine of incorporation by estoppel. Here, National Bank treated Software Inc. as a valid corporation and believed that it was. National Bank used Software Inc.'s projected income in providing the loan, secured the loan based on Software Inc.'s accounts receivable, and only ever looked to Software Inc.'s, not Lenny's, accounts when issuing the loan. Because National Bank treated Software Inc. as a corporation, it will likely be estopped from denying its existence, and Lenny has another way to avoid personal liability on the loan. Finally, however, while Lenny can likely avoid personal liability on the loan, under either the de facto corporation doctrine or the doctrine of incorporation by estoppel, Software Inc. won't escape liability. Because it engaged in the contract with National Bank, Software Inc. will remain liable on the loan to bank. Okay, that takes care of our first hypothetical. Let's turn to one more, shorter hypothetical that covers pre-incorporation liability for a person who may be the business owner or an agent who enters into contracts on behalf of the corporation prior to incorporation. Our next hypothetical is adapted from the 2005 California Bar Exam Corporations question. Molly and Ruth were partners in the operation of a dry cleaning store. Molly and Ruth decided to convert their partnership into Dryco Inc., a corporation to limit their potential personal liability. Prior to incorporation, Molly entered into a contract on behalf of Dryco with Equipment Company for the unsecured credit purchase of an environmentally safe dryer for $100,000. Equipment Company was aware that Dryco had not yet been formed. Equipment Company delivered the dryer 1 week after the incorporation, and Dryco used it thereafter and made monthly installment payments. After purchase and installation, Dryco incorporated in compliance with all statutory requirements, and Molly and Ruth observed all corporate formalities during the period of Dryco's existence. 1 year after incorporation, however, Dryco became insolvent and dissolved. Now, with those facts, let's take a look at our questions. Can Dryco be liable to Equipment Company for the remaining balance? Can Molly be held liable for the balance owed to Equipment Company? To answer these questions, let's go over a few additional rules and terms. As we noted before, a promoter is a person who acts on behalf of a corporation that has not yet been formed. Under the RMBCA, a promoter is personally liable for a contract when the promoter purports to act as or on behalf of a corporation, knowing that no corporation is formed. Importantly, our knowledge element requires actual knowledge. As with nearly all of our rules, we've got an exception. A promoter will not be liable if 1, there is a subsequent novation. Now recall that a novation is an agreement by all parties to substitute the corporation for the promoter and to relieve the promoter of the contractual obligation. Or 2, the contract explicitly provides that the promoter has no personal liability on the contract. On the corporation's end, the corporation is not liable for pre-incorporation contracts entered into by a promoter unless the corporation expressly or impliedly adopts the contract after it is incorporated. A corporation can expressly adopt a pre-incorporation contract, for instance, by action by the board of directors or by reference in the corporation's formation documents. Implied adoption occurs when the corporation both 1, has a reason to know or knows the material terms of the contract, and 2, accepts some benefit from the contract. Okay, now with those rules in our rearview mirror, let's tackle our question. So first, let's assess Dryco's liability to Equipment Company on the contract, which was entered into prior to Dryco being formed. As we did in our first hypo, let's see if any other doctrines apply when we don't have a de jure corporation. We know immediately from our facts that the contract was entered into prior to formation. Here, because Equipment Company entered into the contract knowing that Dryco wasn't formed yet, it raises the issue of the doctrine of incorporation by estoppel. Equipment Company treated Dryco like a company because it knew that Dryco had not been incorporated yet, and also acknowledged that Molly was entering into the contract for the dryer on behalf of Dryco. Moreover, Equipment Company installed the dryer at the place of business and accepted money from the installment agreement. As a result, a court may find that the doctrine of incorporation by estoppel applies, and Equipment Company would be estopped from holding Molly personally liable. In addition, Dryco's liability, with its remaining assets after dissolution, depends on whether Dryco adopted Molly's pre-incorporation contract. As we know, a corporation can either expressly or impliedly adopt a pre-incorporation contract. Now, nothing in the facts indicates that there was an express adoption of the contract, so let's assess whether there was an implied adoption. Here, Dryco did have a reason to know about the contract. The dryer was delivered after it was incorporated, and Dryco continued to make monthly installment payments on it. Dryco also benefited from the contract. It got continued use of the environmentally safe dryer for its business. As a result, a court will likely find that Dryco impliedly assumed the pre-incorporation contract and would be liable as a result. Now let's still assess whether Molly can be liable for promoter liability if the doctrine of incorporation by estoppel doesn't apply. Here, Molly was clearly acting on behalf of Dryco when she entered into the contract. In addition, the facts don't indicate that the contract provided that Molly had no personal liability, nor that Dryco engaged in a subsequent novation. So if our handy doctrine doesn't apply, then Molly could be liable under promoter liability to Equipment Company alongside Dryco. And with that, we are out of time. Hopefully you found these examples to be helpful reminders of how to tackle corporations, formation, and pre-incorporation liability questions. If you're studying for the bar right now, I would definitely encourage you to practice these 2 bar questions on your own, or you can use tools like our Brainy Bar Bank tool to look up California or UBE questions that also focus on corporations and its companion topics, agency and partnership. I also want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of useful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California bar exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a moment to leave a review or rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you're in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.